Are you legally allowed to sing covers on social media? Let's talk to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that's dedicated to all things intellectual property.
Tony, we've been talking a lot about whether or not you can stream music on live streams, on social media, on events, and a question that keeps coming up is, can people sing covers of songs on live streams? So from a legal perspective, what do we need to know?
So I think the best place to start is to understand that in the music space, it is a very unique touch point when it comes to copyright ownership, because traditionally, if we're talking about, let's say, a book, artwork, sculptures, it's pretty linear. It's always going to be one specific copyright, the copyright to a book, the copyright to artwork, a film, so on and so forth. But with music, there are actually two copyright ownership interests at play. There's the underlying musical composition and the sound recording. So the underlying musical composition would be the sheet music, the lyrics, the notes. And what I often tell my students is the two-dimensional version of a song. So think of, let's say, the lyrics of one of your favorite songs. In this case, I'll use Toto's Africa. It's going to take a lot to take me away from you. There's nothing that 100 men or more could ever do. I bless the rain down in Africa. It's going to take a lot to get the things we never had. I'm showing off a little bit. Anyway, so the way I'm reading it monotonously like that, those are the lyrics. That is part of the underlying musical composition. The notes associated with the chorus, verse 1, verse 2, the bridge, all of those are also part of the underlying musical composition. But then we get into the second copyright, the actual sound recording. That's when you take that underlying musical composition, that actual song that you've written out the lyrics for, the notes and whatnot, and now you bring it to life by having a band, by having performers, by having a singer, actually all come together to make that song come to life. So now what is otherwise a two-dimensional version of a song now all of a sudden becomes three-dimensional by actually bringing it to life and singing it out loud. So those are the two copyright ownership interests at play with music. Now, if we're talking about covers, let's think analytically for a moment. Are you using the actual sound recording of that song when you're doing a cover? Typically not. You're doing your own take of how you would sing a song. Mm-hmm. So typically a lot of cover artists may have a stylistic way of pronouncing notes. They may have a way of dragging on a specific melody. They may have sort of like a baritone tone or a soprano or a tenor, whatever it is. They have different, octaves when they sing. Mm-hmm. So of course, because of that, they're probably going to have their own take, their own spin on singing. Mm-hmm. So if you're going to do a cover, odds are the only copyright that you're really going to be using in that context is going to be the underlying musical composition. You're using someone else's lyrics and potentially the notes. If you're, let's say, composing it, let's say on a piano or on a keyboard or some other instrument, you're composing it organically on your own. You're just doing your take of that song. Mm-hmm. So if you plan on doing a cover, in this case, you would need to get permission from the copyright owner of the underlying musical composition, which is typically going to be a music publisher. 99% of the time in the music industry, music publishers like Sony Music Publishing Group, Universal Music Publishing Group, Cobalt, a lot of these big name music publishers are the copyright owner of these major, underlying musical compositions for songs for major artists. There is the unique exception that some artists own their own copyright to the underlying musical composition. Great example of that is obviously Taylor Swift. That's how she's been able to recreate her own music without getting in trouble with Big Machine Records and obviously Scooter Braun. So, again, that's, I think, a unicorn scenario in what is a common industry norm. But that said, if you plan on doing cover, you need to go to the music publisher and you need to acquire what's called a mechanical license agreement. And that basically gives you permission to create either a sample from the song or to even do a reperformance of that song a la a cover. So it lays out all the permissions. And furthermore, it sets out the license fee that would be paid for permission to do a cover of a song. And it also lays out royalty payments that would be owed potentially to that copyright owner who actually wrote the lyrics for that specific song. Sometimes there's one songwriter, sometimes there are two. There could be upwards of 10, maybe even 20. There are a lot of songs that have a lot of collaborative writers involved. So, the net is cast pretty wide depending on what the song is. So that's a traditional industry norm. And I think that if you're planning on doing a cover, whether that's for TikTok, for Facebook, for Instagram, even for YouTube, if you have a YouTube channel that is dedicated to doing covers, you're really going to have to really dot your I's or cross your T's here and know that basically the proper way to do this, the kosher way to do this, is by getting that mechanical license agreement from the music publisher, especially because at the end of the day, what you don't want is a takedown from the copyright owner saying, hey, you sung this song without my permission, or, I'm owed a royalty. So go about it the right way, identifying the copyright owner of the underlying musical composition, contacting them for permission, getting that license agreement, and you're well on your way to success.
That makes a lot of sense. So what happens if people are then just doing these covers because they feel like doing them?
So if you do it, there is one light provision in the Copyright Act of 1976, which basically says that you would then enter automatically into what's called a compulsory license, meaning that you almost automatically are using someone else's copyrighted work, but by doing a cover, let's say, that automatically creates a trigger event where now, if let's say there were royalties or payments that were made to you, let's say for every play on Spotify or on TikTok, especially if you generate money on there, that every amount of money that you make from your cover being featured, that should automatically trigger a royalty payment to the origin copyright owner of that song. That's the general nature of how compulsory licenses work. They're a little bit convoluted, and in my opinion, I think they go against the grain of licensing, generally speaking. I think that, we live in this culture where piracy is very much alive and well, and more so proliferated because of social media. It is rampant. So if we're in this business of protecting our IP, enforcing it, making sure that no one else infringes on it, I think that engaging in a compulsory license inherently goes against the grain of what the general nature of licensing is all about. So I think that if for a lot of people that would rely heavily on the compulsory license front, I think you should somewhat think twice, because the industry norm has always dictated that licensing is the way to go. So mechanical licensing, and again, in this scenario with covers, is the right and appropriate measure to go for, rather than just winging it and hoping that the compulsory license provision in the Copyright Act of 1976 is going to go your way.
And the beauty of YouTube is that they're very clear on this. They have those conversations with their creators. And then if you do something without having that license, they're going to take care of this. They will be giving those royalties to the person who deserves them and not you. So that could actually not only ruin your chances of having monetization to begin with, it can also take down a good part of your channel if you continue to do so. So making sure that you have that proper licensure is incredibly important as a creator for your live streams, for your videos, and for anything on social media. We do have videos on live performances. We have them on doing things with live streams. So make sure you check out the playlist down below. And as always, you can reach out to Tony on his social media with more questions. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And you can check out my entertainment law podcast called End Scene. New episodes drop every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions down below, because Tony is coming back to help keep us legally protected on social media. And we want to make sure we're getting your questions answered. And we're also dropping daily videos to help you navigate the world of your social media marketing and building your online business to make this your most profitable year ever with the least amount of stress that you need to be exerting into your business. We'll see you in the next episode.